Major breaking news out of the U.S. Supreme Court, and it's bad news. In a 5-4 decision, the Supreme Court has voted to grant the stay request by Merrick Garland and Joe Biden, which means that the so-called ghost gun regulations dealing with weapons parts kits, as well as the expanded definition of frame and receiver, have now going to go into effect because the lower court said these were unconstitutional and illegal, but the Supreme Court is staying that decision pending the outcome of that appeal in the Fifth Circuit. And as a consequence, these laws are going to go into effect now, which is most unfortunate. But let's break down what happened, and we'll talk about what happens next in a minute. Hey folks, I'm Mark Smith, host of the 4Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new bestselling Disarmed, What the Ukraine War Means for Americans, involving the right to keep and bear arms. All right, folks, I'm not going to sugarcoat this. This is bad news. Is it horrific news? It's not horrific news, but it's bad news. That is that the so-called ghost gun regulations, which allowed the ATF on their own initiative through just the magic wand of regulations without going to Congress, they were allowed to, they went out and expanded the definition of frame and receiver and included the definition of weapons parts kits within the definition of firearms under the Gun Control Act and the NFA and so on. And the Fifth Circuit Court of Appeals down there in Louisiana, Texas says this was unconstitutional, illegal. So did the district court there. Merrick Garland and Joe Biden immediately took an appeal seeking a stay, which means a pause, to the U.S. Supreme Court in a 5-4 decision. The Supreme Court granted that stay in favor of the federal government, Joe Biden and Merrick Garland, against American gun owners. That's the bottom line. The 4 justices that opposed the stay or would have voted against the stay and did vote against the stay were Justice Clarence Thomas, Justice Samuel Alito, Justice Neil Gorsuch, and Justice Brett Kavanaugh. So that means that the 5 justices that voted to stay the lower court victories in the Second Amendment favor were, of course, the 3 liberals who are just guaranteed left-wing votes on everything. They're not going to even think about this. It's just knee-jerk liberals don't even count them as left-wing votes. They'll never do anything other because left-wing people never ever do anything other than what's best for the progressive cause. We saw that with Ruth Bader Ginsburg, and we're going to see it here and go in the future with the justices of Sotomayor, Brown Jackson, and Kagan, of course. So they were given anti-gun votes. We don't even have to think about them. That's like saying water's wet. So we don't have to think about them, but they, of course, voted in for the government here. And that means that the 2 justices that were the swing votes here were Chief Justice John Roberts and Justice Amy Coney Barrett. Now, before we get too panicked here, and I'm not happy, I'm not going to sugarcoat this, I'm not happy. But I don't think at the end of the day this signals what's ultimately going to happen to this regulation, but it's very annoying and wrong in my view that what appears to have happened is that Amy Coney Barrett and Chief Justice Roberts are basically functioning as institutionalists here, deferring to the federal government's interest, which I think is BS when it comes to constitutional rights and a rogue presidency that's just making stuff up with a pen and a phone. Nevertheless, I'm not on the U.S. Supreme Court, so there's only so much I can do. Now, I do want to get geeky for a minute for those of you who want to understand what may have happened. Now, we know that there's a technical issue here which may have played a role. And I did not emphasize this in prior videos because I don't think at the end of the day it's a huge deal, but it is kind of a technical big deal in some ways. And that is that the law that was applied here, dealing with whether or not this regulation involving so-called ghost guns, a propaganda term by the left, of course, whether or not this law could be vacated is a technical legal question under the Administrative Procedural Act, which is a federal law that explains what remedies can be entered by a court if they find that an administrative agency like the ATF exceeds its authority with the regulation. And that is whether or not the doctrine of vacatur, which means to vacate the regulation or rule, is applicable, is allowed under the Administrative Procedural Act. Now, I think that it's clear if you look at the records of John Roberts, he does think that vacatur is available remedy under the Administrative Procedural Act, which means the only reason why Justice Roberts would have granted the stay in this case, I suspect, is that he must think that the textual arguments that the ATF has the authority under this relevant statute, he may think that the textual arguments have some merit, which I think is not true, but he may have thought it was a close enough call to have granted the stay and maintain what he would have considered the status quo, which is the government's regulations on these ghost guns, on these weapon part kits, on these frames and receivers. I think it's totally wrong, but, I don't control Chief Justice John Roberts. Beyond that, Justice Amy Coney Barrett, I don't know why she did what she did. It could be she just wanted to defer to the federal government. She may think the textual arguments by the ATF has merit, or she might technically think that under the Administrative Procedural Act, the lower courts lack the authority to vacate regulations and rules that they think exceed the scope of their statutory enabling laws. So again, I don't know why Amy Coney Barrett or John Roberts did what they did, but the bottom line is, whatever it is, they were clearly trying to follow the law. And, I'm just going to step back and talk big picture for a moment. And that is, back in 2006, I wrote a book called Disrobed, which was somewhat radical at the time. And basically, I pointed out that the problem is that you have a situation in the courts where left-wing judges simply do left-wing things without regard to the law, at least when it comes to cultural issues like guns, abortion, gay rights, affirmative action, any of these sort of hot-button topics. You could just count on the left to do whatever is good for the left. They're just going to vote for the left. They're not going to care what the law says. They just don't care. They're going to do what the liberals want. That is just the black letter law of liberalism, as I see it when it comes to the courts and how judges function. And this is a strategic disadvantage I have found, and I've written about this before, that conservatives are trying to follow the law, no matter where it takes them. As a consequence, you do have so-called Republican-appointed judges or conservative judges who try to get it right, who try to follow the law where it takes them, even if it gives rise to a policy preference that they themselves might not like. This is what Justice Scalia always talked about. And I do think that it is a strategic disadvantage to have conservatives trying to do what the Founding Fathers intended, to try to understand what the text of statutes mean, to try to understand what the law means, and try to apply it fairly regardless of the political outcomes. It is a great advantage, I think, that the left has, that their judges just don't care. They're going to do what they think is good policy, and they don't care what the law says. That's my sense, and I think I'm right on this, while the conservatives are trying to get it right. And I think in a case like this, where this motion for a stay, there's no doubt that the left was going to vote against the guns in this. They didn't even have to read the briefs to vote, right? In contrast, you have, our justices, if you want to call, not that there are justices, but Second Amendment justices, those that at least support the Constitution as written, at least that's what they say they do. Well, again, here's an example where they probably thought that there's legal arguments and legitimate arguments and fair arguments and and they start taking all these considerations into effect, which is a good thing in many respects. You want judges that are going to follow the law no matter where it takes them. That is a good thing, and it's good that we have the rule of law instead of the rule of people. The downside, of course, is that the left doesn't really play that game. They don't care about those things as I see it. They just care about outcomes. And I do think that is a strategic disadvantage for quote-unquote conservative jurists who are trying to get it right, because they're up against jurists that simply don't care what the law says. They just care about outcomes. And if you're up against somebody that only cares about outcomes, well, again, it's many respects better and easier for them to prevail in their view of the law and American life than for those that respect the Constitution and think that the Constitution as written should be respected and followed. It's a great advantage the left has over the conservative justices, is just my big picture take. But I digress. The bottom line here is that the stay has been entered. It will remain in place until either the stay is either the government wins in the Fifth Circuit Court of Appeals, which I don't think is going to happen, and if the government loses in the Fifth Circuit Court of Appeals, because what the next thing is going to happen now is the Fifth Circuit Court of Appeals is going to hear this case. I think oral argument is in a month. They're going to hear this case and issue a final opinion, ruling on what they think should happen, and then after that, one side or the other can take an appeal, seek certiorari to the full Supreme Court for a full-blown decision. And I think there's a good chance that the U.S. Supreme Court will take the case. In fact, I think they almost took the case now, which is why I think it took them 5 days to make this ruling. I think they were considering whether or not to take this case on cert right now this term. And obviously they chose not to do so and sent it back to the Fifth Circuit. So anyway, this is not good news, but I think it's not terrible news. I don't think this says that this rule is going to be the law forever, but it is very irritating to me, and I'm sure all of you, that we have to sit and wait and wait and wait. Because as you know, justice delayed is justice denied, and I feel that justice is being delayed here for institutional considerations that should not be should not take precedence in this instance. Nevertheless, we'll see how it plays out, and we'll keep you informed as things progress. The war is not over yet, folks, for our rights. We still are fighting on. And remember, every single day we have our guns in America is a good day for freedom. Okay, folks, hope you learned something here today at the Four Boxes Diner. Sorry I couldn't bring you better news right now, but there'll be happier days down the road. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.